Okay, good morning. I think we'll get started. So, what I'm going to do is I'm going to be going through a presentation, and then after the presentation is done, there will be lots of time for questions. So, as we go through the presentation, please just keep a note of any questions that you have, and feel free to ask me at the end. I won't be able to see the chat while I am doing the presentation, just because of the way my slide sharing is working and my general overall knowledge of computers. So, my name is Jessica Chapman, and I'm here to present on family law as a driver of human rights on Gender Based Violence Day. And so, I've put together a presentation. I have an agenda. So, first, I'm just going to go over my bias and background, some definitions. I'm going to talk about family law and human rights and family violence and human rights. I'm going to talk about challenges and opportunities. I have a call to action. And then, of course, we have time for questions and answers. So, I'm a settler. I'm a white cisgendered woman. I have been middle class for my entire life. I'm not a person who has had to worry about being housed or fed. So I think I'm relatively privileged. I'm Alberta born and raised, and I wrote in here that that has to affect a person in some way. And as I was driving to work this morning and listening to the Alberta news, and also following a truck that had a sign on it that said, I identify as a Prius on this gigantic truck, and realizing that there's a lot of anti-trans sentiment in Alberta. um, I was thinking, yes, it does. Like, you grow up in this environment, and it takes a toll after a while if you have opposing ideals. It's only been about 10 years since I started to recognize my own privilege. So I think that I'm kind of at the beginning stages of really understanding the nature of my privilege, trying to learn continuously. I'm not an academic, but I have had the benefit of getting to learn from Dr. Bala, Dr. Jaffe, and Professor Kashan. And I wish I was smart enough to be an academic. So this presentation is more coming at you from my work as a trial lawyer in poverty law at Legal Aid Alberta. I've been at Legal Aid Alberta for 7 years. Before that, I was in private practice for 12 years. And I've been practicing family law throughout that entire time. Practicing family law operating in the legal aid clientele is a little bit different because the needs are different and the issues are different. Um, and I really enjoy that work. I also sit on the board of the Alberta Council of Women's Shelters, and the Legal Education and Action Fund, the Edmonton Branch. I am a feminist, and I approach family violence as a gender based problem. So, when people think of human rights law, they don't often start talking about family law. And I have been sitting with the realization that the work that we do as family lawyers can have a profound effect on the society around us, whether it is a good effect or a bad effect. So, family law is the branch of law that deals with matters relating to the family. And so I've listed the issues there. So, marriage, separation, divorce, parenting, support, dividing property, adoption, family violence. And in my estimation, it includes child welfare law as well. I also practice in the area of child welfare. Um, I was rereading the Universal Declaration of Human Rights and looking at it specifically to see where it collides with family law. So it does identify family as a basic unit of society. The Declaration of Human Rights also talks to the right to safety and security of the person and for having basic needs met. Um, there is discussion about the right to move throughout. your country and in and out of your country. There's some things that I think directly conflict with some of the principles of human rights in family law. For instance, Article 12, it says that no one shall be subjected to arbitrary interference with his privacy, family, home, or correspondence, nor to attacks upon his honor or reputation. So when you're reading that, you can see how some of the things we do in family law and the way that family law has evolved in Canada is to make the personal political in a way, and to family law really takes the what happens in the privacy of a family and puts it in a fishbowl for a judge to examine. So we'll be talking a little bit about that. There's also the other part that I wanted to talk about was the Convention of on the Rights of the Child, and that's, I think, directly applicable to family law operating human rights. One of the things that is contained in the Convention on the Rights of the Child is for children to be able to have their voice heard in any court proceeding that affects them. And so that is quite an important part of family law as well. So I see family law as an implementation tool to get human rights fully realized. And so I was thinking of it in terms of being a driver. A driver gets you from A to B, and family law can be that driver. So to sort of show how family law has uh, had some very big effects on rights of different groups, I wanted to just go through what I see some of the big innovations in family law. So we had the Dower Act, which was very basic property protection for spouses, where if it provided for life estates and was an attempt to make sure that people, mainly wives, would not lose their homes in the event that their husband left them, and also that the property couldn't be mortgaged without their or otherwise disposed of without their consent. So that's pretty basic protection. It's still in effect today. Um, there is discussion in sorry, it's still in effect in Alberta today. I realize there could be people from other jurisdictions. Um, there's discussion by the Alberta Law Reform group that they are considering getting rid of the Dower Act. It will be interesting to see how that affects um, the area of real estate going forward. It won't really affect family law so much because there's other property laws in effect now that sometimes conflict with the Dower Act. In Canada, the first unified divorce law was enacted in 1968. At that time, the grounds for divorce were either a matrimonial offense, mainly adultery, I would say, or marriage breakdown, but you had to have a separation period of 3 years to prove the marriage breakdown. A lot of my clients complain about having to wait a year to have a divorce granted on marriage breakdown. So I imagine that 3 years might have felt a bit interminable to people. No fault divorce started effectively in 1986 when the only ground for divorce became marriage breakdown. You could have marriage breakdown on three different bases, and that would be either separation of 1 year, or adultery, or mental or physical cruelty. Even if you use the other two reasons, adultery and mental or physical cruelty, there would still be a no fault divorce that would proceed. Um, One of the most important innovations in family law has been the concept of child support and creating a unified approach and a principled approach to child support across the country. In 1997, the federal child support guidelines came into effect, and those were used for people who were getting divorced. The federal child support guidelines are a regulation under the Divorce Act. It set out payment of child support based on the payer's income and the province in which they lived. And there are tables of child support. Before that, child support was totally discretionary. Um, there was some law in it, but essentially judges would assess the situation and decide what needed to be paid. So starting in 1997, there's a really principled and consistent way to deal with child support, but prior to that, there wasn't. So, with respect to spousal support, again, some people call this alimony. It's also called partner support if you're dealing with unmarried people. Um, there is no official law making the spousal support advisory guidelines. Um, it's not a law that is imposed. It was an approach that was developed by some family law experts, including very experienced lawyers and then professors in the area. And there was a draft proposal in 2005, and the final version was put out in 2008. And this also represents a principled way to calculate spousal support in a way that's consistent. um, Many of the courts in Canada have adopted the spousal support advisory guidelines. Not all have, but still, they are at least a starting point for lawyers to use in negotiations and to be able to provide to justices so that they can take them into consideration when they're making their decisions. Parenting has also evolved over time. Um, when I started practicing family law, the trend was to try and have um, shared parenting as much as possible. Um, Now there's a bit of a pulling back from that particular position. There's research being done into what's best for children, and um, so the courts try to be up on various things like attachment theory and all of those kinds of things as they go along. There's also the acceptance in the legislation and by the courts that no child is exactly the same as any other child, and what works for one may not work for another. So we always express this in the best interests. One of the things that has evolved over time is the language. So a lot of people still talk about custody and access. A lot of people talk about full custody. Um, the What we're really talking about is a division of time for the children and also who's going to make the decisions for the children. And that is how we are trying, that's the language we're trying to use now. With property, there's been legislative regimes for married couples for a long time. However, when it came to common law spouses, it could be difficult to know how things would turn out. When so there, the lawyers would rely on the law of trusts and use constructive trusts in order to establish rights for common law couples in court. Over time, legislation has extended property rights to common law spouses. If one of the problems is that there's no real um, consistent definition for common law spouse, and different provinces have different ways of defining it. In Alberta, in order to be inclusive, and to avoid using the word same sex marriage, the government at the time decided that common law spouses, for the purposes of Alberta legislation, would actually be called adult interdependent partners. And so that's why you'll see on my slide that I have the lovely acronym of APES. Those are actually marriage like relationships. And there's some rules about what qualifies you as an APE. In Alberta, you have to live together for a period of 3 years, or it could be shortened. That time period could be shortened if you have a child together. And that's for the purposes of spousal support under the Family Law Act. You need to be an APE. Um, and for other different provincial benefits. But if you look at something like the Canada Pension Plan, it's going to have a different definition of whether or not you're a common law partner under their act. I think for benefits under different, um, like extended medical and dental benefits under different insurance companies. They're going to have different definitions. There's no one definition for that. Um, on July 20th, 2005, Canada became the fourth country. I was looking this up and I was very surprised once again to realize that we were only the fourth country at the time to legalize same sex marriage. So that is, if family is the basic unit of society, then everyone should have marriage rights. And this is one moment in Canadian history that makes me proud. Um, in Alberta, the legislative extension of property rights to non married couples um, has been so for property rights, that became legislatively enshrined on January 1st, 2020, where anyone who separates after that date, if they're not married, they have access to this essentially the same legislation as married couples. But other rights, for instance, under the Wills and Estates Act, under the Protection Against Family Violence Act, those have all been expanded over time to non married couples and families. There's some areas where we need further work for sure. Um, I talked about having a unified definition of common law or equivalent to spouse. I think there's going to continue to be different ways of organizing families and caregiving and associated rights and entitlement. Um, People are talking more openly about polyamory. There was a case out of Ontario where two women were raising a child together, and they were having difficulties because they didn't fall into the definitions under family law for guardianship and that sort of thing. So that's what I'm calling a friendship family. I think there's going to be a big increases in people undertaking elder care. I know that there's a lot of people doing it already, and there may have to be some sort of support regime worked out for that. I think we're going to have to continue to fight the same fights over and over again. Um, and to especially in the area of 2S LGBTQIA plus people, I think that we're seeing a lot of backlash at this particular point in history, and we can't really let our guard down when it comes to um, making sure that people's human rights are guarded. And I feel the same way about women's rights. You can see the rollback of abortion rights in the US, for instance, and I think we should all be really, really concerned about the attacks on basic human rights that are occurring. Um, I think that there's a lot of room for improvement in family violence. That's a big part of my legal practice. And again, I've consistently used family violence as the term throughout this presentation because I'm talking about family law, but I'm also talking about domestic violence, intimate partner violence, and all of these things tend to be gender based violence. So, I wanted to talk a little bit about family violence and how big the problem is. In my view, it is one of the biggest problems facing society, and I don't think that we can have peace in the world until we have peace in the homes. I think we're creating patterns where family violence is very normalized, and um, that those patterns repeat themselves. And so I am of the view that we need to adopt a zero tolerance for violence in our homes and not be showing that to children or anyone else. Um, I take a pretty strict view on what should be permissible, and courts are not going to agree with me that yelling is impermissible. But if there's something to be said for nonviolent communication and how that can travel and reinforce itself in the world. So, in terms of some statistics from Statistics Canada, of all the reported violent crime in Canada in 2019, more than a quarter, so 26%, were the result of family violence. That's a lot. That's also only what is reported. Um, in in 2019, we Alberta was winning when we had the third highest number of police reported family violence victims from across the country. Not a proud moment in my Alberta um, living. Police have reported that what's being reported to them has increased 3% in 2021 compared to 2020. And that was the seventh consecutive year with a gradual increase. We know that family violence is very underreported, and it's such a common problem. But what I run into when I'm talking to victims and survivors of family violence is they feel very alone. They feel like they're the only people dealing with the problem, and that they should be ashamed of what's going on. But it's such a common problem. Definitely everyone who is watching this knows someone who is going through family violence or is probably going through you may be going through family violence situations yourself or have dealt with it in the past. So according to the study done by Statistics Canada, 1 in 5, so 20 the police are getting 20% of what's actually happening. Um, so the police are dealing with a small share. I work in a program at Legal Aid Alberta called the Emergency Protection Order Program, and we assist claimants with getting emergency protection orders, and um, and then we help them as well deal with the reviews at Court of King's Bench. It's a free service provided to any claimant, regardless of their income. The respondents, their first appearances are at the Court of King's Bench, and they are also entitled to a free duty counsel lawyer from Legal Aid, regardless of income. And we provide that service as well, but we send it out to roster lawyers. I should have mentioned at the beginning that I'm actually a staff lawyer at Legal Aid. I only do legal aid files. So what you're seeing in these numbers here are the numbers of EPO files through our staff offices, which represents the number of claimants we've dealt with in each of those years. There are some claimants that don't get assistance from legal aid because there are some areas that geographically fall outside of what we can do. We're always trying to do more, but we, of course, like everyone else, have limits. And there are some people that choose to self represent as well when they're dealing with their emergency protection orders. I wanted to talk a little bit about how family violence is defined by each of the acts. The Protection Against Family Violence Act, which I've just used a handy acronym of PAVA, that came into effect in 1999 in Alberta. So this was quite a while before, we were talking about coercive control. Lots of places weren't even talking about stalking in 1999. So I am quite proud of the government that brought this in because I think it's a pretty inclusive definition of family violence. It's any intentional or reckless act causing injury or harming a family member, or that intimidates a family member by creating a reasonable fear of injury or property damage. Um, Damage to property is included, forced confinement, sexual abuse, and stalking. Um, so I think that although it doesn't include coercive control in this definition, I think that some of the patterns of behavior can definitely be used to prove family violence under this definition. I should mention that when we're dealing with family violence under the Protection Against Family Violence Act, it's not just intimate partners. Family is defined very broadly. It could be past or present spouses, and that includes common law or equivalent to spouse relationships. It includes people who are residing or resided together in an intimate relationship. That often makes for very awkward questioning on the record. Um, there's no minimum amount of time you have to live together to qualify, but there has to the oh Sorry, you shouldn't hit the rolly button on your mouse because it just makes everything move. So hopefully no one got motion sick. Um, you you just have to have had an intention of some permanence. You don't have to have promised that death will do you part. You just have to have intended to live together. So, we've had all of the claimants' items were at the apartment. A major incident of violence occurred, and the justice did find that because there had been this intention to live together, and the stuff was moved in, so they were living together, albeit for a very short period of time, that they would qualify for an EPO. If you have children with someone, then your family members. If you're related by blood, marriage, or adoption, your family members under the Act, and any children who fall into the care of any of the above. It also covers sort of adult guardianship um, situations. So there can be quite a lot of people included under under the EPOs. There are other protection orders, of course, available under the common law in Alberta, and those are restraining orders, which can apply to any individuals. You don't have to be family members. I know that there are different types of protection orders across the country with different legislation. I was recently looking at Manitoba. It was quite interesting because there was no time limit set on how long a judge can make a protection order, whereas under the Protection Against Family Violence Act in Alberta, the maximum these orders can stay in effect is a year, which seems like a long time, but when you have claimants who are needing continued protection, a year goes by pretty quick. In Alberta, we have the Family Law Act, and that came into effect in 2005, and it applies to both married and unmarried couples who are going through separation. Family violence is only defined in the Act in relation to considering parenting, and it's enumerated as a factor under the best interest of the child. And it's defined as including behavior by a family or household member causing or attempting to cause physical harm to the child or another family or household member, including forced confinement or sexual abuse, or causing the child or another family or household member to reasonably fear for his or her safety or that of another person, but does not include, and I should mention that the definition of violence under PAVA also makes sure that you are still allowed to use force to correct your children. So I haven't looked that up in other provinces, but I think it's a point of interest. It also allows for it. This definition also allows for self-defense and defense of another. The Family Law Act specifically says that the presence of family violence is to be established on a balance of probabilities. Now, this is the reason that I really think family law is the place to deal with family violence. I don't think that the criminal law system can adequately deal with family violence. It because of its nature. Family violence occurs in private generally. And so police and crown prosecutors are often left with a he said, she said situation. Um, and that's what we hear a lot from police and from claimants who say, the police told me it was a he said, she said, so they told me to get an EPO. In criminal law, I understand why they say that. I do think there are times when better investigative techniques could be used, but I also understand that everyone is generally overworked. In criminal law, you have to prove things beyond a reasonable doubt. In family law and all civil law, you have to prove things on a balance of probabilities. This makes proving family violence a more reasonable task in the family law system, and that's why I am choosing to focus my efforts there. Now, the Divorce Act was just updated in 2021, and it includes in its definition coercive control. It lists a lot of the things contained in the other definitions. It specifically talks about killing or harming animals, and um, the research has indicated that that's a pretty good precursor for killing or harming people. It talks about psychological abuse and financial abuse, which are not necessarily specifically talked about in the other definitions. The failure to provide the necessaries of life. Um, and I think the rest are basically included in the other definitions. But I see this change to the definitions as a real opportunity um, to create some new law and deal with things in a better way for the people that have suffered from um, domestic violence. I also just wanted to state that violence affects, so I said it's gender based, but there's also, for instance, Indigenous women suffer from far greater rates of violence than non Indigenous women. There's there's other factors that make people more vulnerable. And so all of those factors can intersect to really create disproportionate effects. So um, there's a lot of academic theory on this, and I'm not going to try to explain it here, but I just wanted to be sure that the audience knows that I am recognizing that. And I think that I thought I had changed my slide to reflect that, and then in the end, must have sent the wrong version out to my person. So there has been some good law that has come out as a result of these changes to the Divorce Act. And in 2022, the Supreme Court of Canada made a decision called Berendrecht and Grebliunas, and they really recognized what family violence, what kind of effect it has on people, and especially children, and specifically recognize that harm can result from direct or indirect exposure to domestic conflicts. It can happen by observing the incident, experiencing its aftermath, or hearing about it. Um, the Supreme Court in this case also recognized how difficult it is to prove family violence and noted the private nature of the violence. And those comments are very helpful going forward because it it gives some guidance on how to prove it and what to do about it. I think that as lawyers, we need to do a better job of putting forth the case about how the family violence is affecting the child or children. Um, there sometimes people say, "Well, I can't prove this happened, so I'm not going to try," or we'll be ruining chances of settlement by bringing up that there has been family violence. And family violence is a common thing. We need to deal with it and we need to start being honest about what's going on in the family so that the best decisions for children can be made so that some of these patterns get broken. There's also a very big problem with post separation abuse, and that's likely to happen when there's been coercive control within the marriage. As the perpetrator loses control of his or her partner, what happens is increased amounts of violence and increased attempts to control. And one of the ways that can happen is through the legal system and in using litigation as an abuse tactic. And as lawyers, we need to be more aware of that and shut it down. And there's no real, I don't have any big, well, I have a couple of ideas, but my main idea about how to do that is basically doing the work and grinding it out and just as the lawyer sticking with it, trying to make it as easy as possible for your client by not, for instance, by remembering the facts of what happened, by taking good notes so that you don't have to ask your client to repeat the same story through court and having to repeat those stories. But also, we know where there are experts. Every shelter is filled with experts on domestic violence, gender based violence, violence against women. We need to put those people in front of the court, get them qualified as experts, and get their advice before the court. I just want to talk a little bit more about what our emergency protection order provides. We provide assistance with the initial application for claimants. We provide assistance with reviews in the Court of King's Bench. If the matter has to go to a hearing, then we can assist people who are approved for coverage, which means they meet our financial eligibility guidelines. And we do education sessions in the community to police officers, to um, sometimes to components of the judiciary, and to other lawyers. I put in the test and for an emergency protection order. As you can see, the claimant and respondent have to be family members. Family violence has to have occurred. There has to be a prospect that the family violence will continue unless there is an order, and that there is seriousness and urgency for immediate protection to the claimant. So that's where I was saying that something that I consider to be violence, such as yelling, would not be considered serious enough or urgent enough to warrant an emergency protection order test. So it doesn't fall into this definition, but there are many other types of violence that would. I did comment that that you or someone you know may be going through a situation of family violence, and I put some places, pretty Edmonton specific, for places you can find support. A really good resource in Edmonton is the Today Center. But there are shelters across Canada, specifically women's shelters, who not only shelter people, not only take them in and give them a place to live, them and their children, but they also provide a wide range of social services and wraparound supports. And they even do so on, you don't have to be living there to receive those services. And of course, there are police services that will assist. More and more police services are having people specifically trained to deal with family violence. As with any other profession, um, different people have different skills, and so you can't guarantee who's going to respond to your call. So I wanted to say some positive things. So, what's going well in family law? Um, there is an increased understanding, especially at the higher levels of the courts, specifically the Supreme Court of Canada and the appeal courts. I think there's um, an increased understanding of how family violence affects children. Those courts aren't dealing day to day with the problems of family violence, but they can make important decisions that guide us. Um, our courts are the judiciary is becoming um, more diverse. I've seen real attempts by judges to be inclusive, and I'm hoping that that will continue. Don't get me wrong, there's still lots of like middle aged white guys getting appointed, but there's a lot of other people getting appointed too. I also think that as the bench um, continues to appoint younger and newer judges, new ideas come on, which is a good thing. There's also been undeniable legislative progress, and I guess I was feeling quite optimistic when I wrote that. But the definition of family violence as contained in the Divorce Act is heartening to me, and I think it provides some opportunities. What needs to change? I haven't really talked about child welfare law a lot, but in terms of human rights, if um, that's an area that needs a lot of work. In Alberta, our courts are the children in care are incredibly overwhelmingly um, disproportionately to population Indigenous children in care. That needs to be fixed. There's a couple of First Nations in Alberta that have created their own child welfare system. I hope that more nations will be able to do that. The federal government did put a good piece of legislation into place called an act respecting um, First Nations, Inuit, and Métis children, youth, and I think families. And that's a tool that lawyers are starting to use to try and get better results, and that First Nations um, and other Indigenous governing bodies can use to make their own legislation. Unfortunately, um, there was the onus is all on the First Nation or Indigenous governing body to create that legislation and to secure the funding to do so. Um, One can always hope that something will be forthcoming, but it is a bit discouraging when you have the federal government fighting someone like Cindy Blackstock in court for decades on these sort of issues around child welfare law. Something needs to be done though, because those kids in care are often getting treated with violence. Their human rights are definitely not being met, and it creates a cycle. We need to make sure that lawyers are educated. I put about family violence, but realistically, they need to be educated in equity, diversity, and inclusion. And our law society in Alberta and our Alberta branch of the Canadian Bar Association is doing a lot of work in this area, but people are resistant. And I guess one of my calls to action is, if you are an old white guy, get down to those seminars because you don't know what you don't know. With child representation, I think this is something that needs to continue to expand. Um, the Convention on the Rights of the Child it came into effect in 1989. Um, the first child representation training that occurred on a large scale in Alberta was in 2005. There's a lot of people doing groundbreaking work, but this needs to be expanded, and we need to make it a normal thing for children to have their own representation. Lawyers need to change how they see their role and the roles of others. Lawyers need to understand that they're not necessarily the experts and that they should seek expertise outside of their fields, especially from shelter workers. I think lawyers in general need to be less afraid of running a trial. Sometimes trials are needed. I know that there can be huge expense, and that's another thing that needs to change. Is there is it's still a system where money will triumph some of the time, because some people just can't afford to run a trial. And so sometimes a person with the most money can sort of fight of war of attrition where a judge never gets to make the final decision. Um, in Alberta right now, we're having a lot of focus. There's mandatory ADR before you can bring a court application. You can apply for a waiver, but it's yet another step, and it's going to be difficult for self represented people to be able to deal with that. I am concerned about the unintended consequences. Um, there's a lot of families, and maybe arguably the vast majority of families are well served by ADR. But for people who have lived in a home where there's coercive control, ADR, in my opinion, will not work. Oh, and I should just define ADR. That means alternative dispute resolution. So that means like four-way meetings or case conference, like settlement case conferences with a judge, mediation. Um, Yeah, and any type of settlement discussions. I think there's some challenges and opportunities. Legal aid funding for family law across Canada is not the same everywhere. In Alberta, we do have certificate funding where and I'm very proud that we have this, and feel lucky that the Alberta government and Legal Aid Alberta were able to create this so people can have their matters fully dealt with. They can have full representation through legal aid. There are some parts of Canada where maybe there's only legal aid, full representation available for child welfare matters. In other parts of the country, there may be only duty counsel and family law courts where they can help you in that moment. And don't get me wrong, duty counsel is extremely valuable, but they won't be able to help you run your matter from beginning to end. Um, as I've said, lawyers need to use the tools they've been given. They need to carefully and thoroughly discuss family violence with their clients. They need to put the evidence forward from the beginning of the file. Now, this, of course, I've told you that I sit on the council, Alberta Council of Women's Shelters. I think that shelter funding needs to be increased. There's amazing work happening in shelters. People get to have a chance at a fresh start, and we need to be funding that because that's going to be good for society overall. I also, as a socialist, which is maybe something I didn't talk about before, we need to have basic and adequate social security for all. Um, you can't leave a marriage if you don't have a place to go. You can't recover from an addiction and get your children back if you don't have a place to live after you go to treatment. Currently in Alberta, the basic adult rate for shelter and living expenses for a month is around $900. If you don't happen to have housing, then you get an amount that's less than that. Sometimes when I'm dealing on a child welfare file, a social worker will say, well, we think this person could benefit from money management. And to that I say, please tell me how to pay for housing and food on $900 a month, and I will happily go to that course myself. But until you can tell me that, I'm not making my client attend such a course. Legal Aid Alberta is 50 years old, and so we started in 1973. We have a website. We're celebrating our anniversary right now during this fiscal year. I'm proud to be a part of Legal Aid. And here's some ways to reach us. So I'll just give you a moment in case you. I think this is recorded and I think the slides will be sent out, but um, please, if you have any questions after this, feel free to reach out to me. I'm going to turn off the presentation now. Okay, I didn't do too bad for time. Um, Now, I want to stop sharing my screen. Okay, so now what I'm going to try to do, and there's no guarantee that I can um, do this, but I might have to, I'm not sure, I don't seem to have a moderator here with me. I think that if you want, there should be a button that you can click and you can request to ask a question or like request to share your screen and then we can kind of see each other. Is there anyone who has a question? Okay, I don't see any requests. I'm hoping that um, breakout rooms. No, I don't want to do that. Is there anyone who has a question? If there's no questions, we might be ending this session early. Oh, I see that there's some questions typed in the chat. So, how can we hold government bodies responsible for underfunding social problems? If only I had the answer to that, but I think the answer is actually voting and advocating on a political level. I think that's the only way to make that happen, is you have to mobilize, which is obviously going to be very hard because the vulnerable people who need this are probably the least able to mobilize. But um, I think that's the only way forward.